Hello friends. Around 10 days ago, I had released a video on section 107 subsection 6 regarding 10% deposit as a mandatory provision for filing the appeal before FAA and the similar amount before the tribunal in addition to 10% already deposited. It is a very shocking provision in my opinion that virtually forfeits the rights of appeal of thousands of people who either face ex parte orders or who face tax terrorism in the hands of tax administrators or who are handled by professionals who are not very efficient to handle these matters. On one ground or the other, if high-stake demands are created, then there is a mandatory precondition in law that you want to file appeal, deposit 10%, and within the limitation period, that is 3 months plus 1 month condonation. And I am told that online appeal cannot be filed at all if there is no 10% deposit. There is no provision in the Act or in the rules where a person who doesn't have money to deposit, he could file an application requesting waiver of a deposit. So in the absence of such a provision, the appellate authorities will be well within their rights to refuse such prayers. So once you do not deposit 10%, appeal goes for S6. And if you had filed the appeal, if you could, within the 4 months, 3 plus 1 month, then perhaps you can file your further petitions, go to SLP in Supreme Court and blah, blah, blah. And the time taken from the first filing of writ petition till the final adjudication by Supreme Court could be excluded for the computation of limitation under Section 14 of Limitation Act. That is, if your appeal was dismissed as not maintainable due to non-deposit, if this could be done even today, and it was done within 2 months, 28 days, and at the end of 3 months you file a writ petition in the High Court, and this carries on till Supreme Court for 2 years, then the period of 2 years can be excluded for the computation of 2 days, that is 28th day of third month to third month end, plus 1 month condonation. So this is the only perhaps a remedy that a law could provide. That too, after a lot of debate, we will discuss this. It's a little longer video. You will have to watch if you understand it fully. As a lawyer, I have been maintaining a position that this 10%, especially in the eyes of GST law, which has subsumed 4 enactments, and it's a pan-India, or it's a pan-global act, where demands could not only be raised due to actions in India, but also due to actions in outside India, where you import some services which you claim tax-free, but which are held to be taxable. There is a video or write-up being circulated that Supreme Court in Simla Gomti Pan Products versus Commissioner GST UP has reduced the pre-deposit from 10% to 5%. This video or write-up is misleading. Why? You will have to watch again this video to really understand this judgment. These judgments went to Supreme Court by way of SLP second time from the judgment of Allahabad High Court. Show cause notices were issued for 2 years, 21, 22, 22, 23. And a second show cause notice was also issued, creating additional demand of 17 crores. The show cause notice were adjudicated and order in original were passed sometime in 2024. The assessee took a plea in High Court that the reports being relied upon in the OIO were not made available to him. They were investigation reports. High Court, believing due process of law, remanded the matter back to the authorities. You provide them and let them file a reply and they re-adjudicate the matter. It was done, demands were created. Assessee filed an appeal without 10% deposit. At that time, it may have been possible. It was dismissed as time barred and also not satisfying the requirements of section 107 within subsection 6, subclause Roman B. Assessee had a first round of litigation before High Court. High Court advocated an alternative remedy plea and dismissed the appeal. The assessee went to Supreme Court by way of an SLP, including making a prayer that he doesn't have money to make a pre-deposit and therefore the authority should be directed to hear his appeal on merits without 10%. Supreme Court did not agree with this prayer, that is 10%, but remanded the matter back to the appellate authority that the appeal is filed in certain time, it will be heard. Again appeal was filed, again dismissed because there was not 10% deposit. Now, prior to this appeal on limitation issue, by way of first writ petition before single judge Justice Jaspreet Singh, the assessee had invoked Supreme Court ruling in MP Steel Corporation versus Customs Central Excise, a Bible law limitation, especially section 14, and based on that ruling, in the earlier case by Justice Pankaj Bhatia, the appeal was remanded that the condonation should be exercised, a condonation application, if made, should be disposed of, keeping in view the Supreme Court judgment in MP Steel Corporation, especially section 14. However, in the same judgment, the Honorable High Court dismissed the plea that section 5 of Limitation Act could be invoked, holding that GST Act is a complete code in itself. Therefore, unless by way of reference section 5 was to be invocable, section 5 could not be invoked. The appellant again went to appellate authority. Now appellate authority dismissed appeal again, that there is no mandatory deposit of 10%. The appellant again moved High Court under Article 226 by way of a second round of litigation by way of writ petition. Here Justice Jaspreet Singh, I believe single judge, by judgment, in detailed judgment, dismissed the writ petition basically on 3 grounds, which are very important to hear. First, the Honorable Judge invoked a Supreme Court ruling based on an English ruling, Henderson versus Henderson, where a principle of law was laid down that the litigating parties cannot get into vexatious litigation. That is, the issues which have been decided by earlier judgment or which were not prayed for but decided, these issues cannot be re-agitated. Second, the Honorable High Court Judge, Justice Jaspreet Singh, noted that this prayer of waiver of pre-deposit was never made before appellate authority. There was no application. By quoting the SLP grounds or the High Court grounds where such an argument was taken, Judge noted, in High Court, though this ground was taken, but during oral argument, it was never pressed. Therefore, there can be no, bone of contention from the petitioner. However, in Supreme Court, in the earlier SLP, this issue was discussed, but Supreme Court did not accept this prayer that appeal under GST law could be made without mandatory deposit of 10%. Therefore, the second writ petition on 11/11/24 dismissed the writ, holding that the petition is misconceived and it is an abuse of process based on Henderson versus Henderson, which was followed by in various Supreme Court judgments that are quoted in the writ order. Now imagine again, the petitioner went to Supreme Court again through Mukul Rohatgi. Mr. Mukul Rohatgi once again took a point. The whole orders were passed ex parte because the petition was not heard, notwithstanding whether he filed the reply or not. And since he has not been heard, it's an ex parte order. This order is based on without material. This is on the face of an illegal order, arbitrary order. Supreme Court heard and passed a 2-page order holding that deposit 3.5 crores. First, show your intention. Amount was to deposit of 67 crores, 6.7 crores. So you were directed to deposit 3.5 crore. And once he shows a proof of deposit of 3.5 crores within the time allowed by Honorable Supreme Court in the second set of SLP, the case has to be reheard. No, nowhere Supreme Court has held that the amount of pre-deposit has been reduced. It is only an interim order just to check the bona fides of the petitioner. Has he come to Supreme Court just to waste their time, or he has the money to deposit? Which the petitioner agreed before Supreme Court that he would deposit 3.5 crores. So friends, this Gomti Pan Masala case, the Supreme Court has not yet reduced the pre-deposit, but has passed an interim order. Now, what are the key issues which we have to learn from this judgment? I have read all the 3 judgments of High Court, 2 of High Court and 1 in Supreme Court. The arguing counsel was confused. If you do not make a prayer in the writ petition that deposit could be waived on ABCD ground, then there is no prayer made. Court will not pass an order. So if you made a ground like this, but you did not argue this while arguing the writ petition, and court says, okay, you file appeal in view of MP General Corporation case, the appellate authority will decide. That is, the case is intended to have been remanded on the question of limitation, not on the question of waiver of deposit. And Justice Singh noted that this issue was settled by Supreme Court, that the precondition of 10% they did not agree to waive. Therefore, they rejected the prayer of the petitioner before the Supreme Court in the first SLP. Therefore, the High Court cannot go into this question again. Now, once you create this kind of chaotic facts, that is, first you did not file reply, you go to High Court, the report was not given to us, High Court says, okay, take the report, order is passed, you file appeal late and without deposit, your appeal is dismissed on both grounds, being time barred and being without 10% pre-deposit. You again go to High Court, Court MP General says Corporation, if Section 5 cannot be invoked, Section 14 can be invoked. High Court agrees with you, directs the appellate authority to consider MP General Corporation. You go back there and your delay is condoned, but there is no deposit. You take a ground, no, this case was remanded. But High Court did not say, okay, you look into the condonation and do not insist on deposit of 10%. So you went to Supreme Court again, Supreme Court doesn't agree with 10%, and he again relegates you to appellate authority. Appellate authority again does the same thing. You go to Supreme Court again. So what happened in 6 set of litigations? We are still there whether the 10% mandatory deposit could be waived by Supreme Court. Supreme Court has not given any inclination in the SLP order passed, which is an interim order passed, wherein Supreme Court has said that we are willing to debate it. This could be a matter whenever it comes for hearing. Supreme Court may not give any finding, may not lay down any law under Article 141 that Section 107(6) subclause B can be read down to mean that appeal could be heard without a deposit. However, my view is, under the circumstances of this particular case, because the appellant has gone through so many litigations without his fault or without his fault of the counsel or various high courts, whatever they have done, Supreme Court might say, okay, this appeal should be heard subject to deposit of 3.5 crores. However, this order, which may be passed by Supreme Court, in my view, will not lay down a law that High Court or the first appellate authorities have been empowered to waive the condition under Section 107 subclause C subclause B of CGST Act. Therefore, like a condonation case which I had made a video, there is a leverage handle given to you that Section 5 could be invoked based on MP General Sales Corporation, that these kind of authorities could be held to be courts. There are contrary judgments, but there is a little leverage available. Delay could be condoned beyond 4 months. High Court under Article 226, in any case, I think they have the power to condone delay. They are not governed by a particular provision under Constitution of India. High Court, Supreme Court being constitutional courts. But the statutory authorities are not constitutional courts. Now, this judgment, whenever it is held, so far there is no stay against the petitioner, because if you deposit 3.5 crores, the department cannot take coercive steps. Now, the litigation strategy here is, should we face high demands like this? The High Court dismissed the petitions of this Gomti Pan Masala company on the ground that the prayer you made, first, were not contested during arguments. Second, if you wanted a waiver of deposit, this ground must be taken before first appellate authority. Let him say yes, no, whatever. So once we take it to High Court via Article 226, the litigation strategy is that this prayer should be accentuated with judgments, with facts, and with sufficient reasons. First, financial constraints, if you don't have money. You have to put documents on record, why don't you have money? Second, you have to prima facie show that the demand so made is untenable in the eyes of law. It cannot stand on the ground of jurisdiction, on the grounds of non-filing of due process of law, on the grounds of the factual metrics of the case, on the grounds that the report being relied upon has no locus standi to be considered in the assessment orders. So, whenever we have a high-stake case like this, and we want to approach Article 226, both judgments of Justice Pankaj Bhatia and Justice Jasbir Singh should be thoroughly read, including Henderson versus Henderson. And then Supreme Court really may not debate on the judgment of Allahabad High Courts. They may, for them it's a very small matter whether appeal could be heard subject to deposit of 3.5 crores. They may impose a condition of bank guarantee. I don't know. It is a view. And normally when Supreme Court passes such interim orders, then generally the SLP petitioner generally will have relief. This is the experience of past cases. But this particular judgment, whenever Supreme Court passes, in my view, will not be binding. This shall be relevant to the facts of this case. Unless the Supreme Court analyzes the law, passes a detailed judgment on Section 107(6) subclause B, and holds that High Court judgment should be read down to mean this: Article 141 will not be unmocked. Well, friends, this is the analysis of Gomti Pan Masala, where the deposit has not been reduced. As people are writing articles in Tax Guru, in other things, making videos, there is no reduction of pre-deposit at all. It is only an interim order passed by Supreme Court. That is why I wanted to make this video. I made a long one because I have read this judgment, made my notes, and I thought, why not my friends should also know this, what is this case about. Thank you so much.